My Lords, I welcome the opportunity to speak today and would like to thank the International Agreements Committee for their excellent report. Just to say, as Lord Bishops, we take no position on this bench based on tribal loyalty, and we are not whipped. But instead, because of what our Christian faith teaches us for care for the stranger, we have spoken with one voice on these benches. I am focusing on the issues before us today. Friends on this bench will speak to wider points in the coming weeks as the bill is discussed. As has been said, this treaty is the central plank of the government's case that Rwanda is a safe country for asylum seekers. As others have commented, it is remarkable for the executive to request parliamentarians declare another nation-state safe and safe ad infinitum on the basis that one drafted international agreement answers all the concerns of the Supreme Court. If Parliament does proceed to effectively substitute its judgment for that of the Supreme Court, I would ask where that leaves the constitutional principle of the separation of functions, and what precedent is this setting? The question is not whether both parties are willing and capable of delivering on the treaty, but whether the provisions will actually become operational in reality. Both the committee and the High Court question Rwanda's ability to fulfil its commitments in the short term in light of the evidential deficiencies of the present asylum system in Rwanda, as has already been mentioned. Furthermore, the UNHCR has not observed any systemic changes that will address the court's concern. Future assurances, however sincerely offered, are not on their own a strong enough basis to legislate a country as safe. The role of government is indeed to create law, but it is not to create injustices. Therefore, can I ask the Lord Minister, if the government is so confident the treaty obligations placed on Rwanda will ensure the Rwandan partnership is lawful, why not make this argument again before the judiciary? As this is a course of action the government is not pursuing, the International Agreements Committee has recommended that the treaty not be ratified until Parliament is satisfied that the protection it provides have been fully implemented. Given that the Home Secretary himself has stated, and I quote, "We will not operationalise this scheme until we are confident that the measures underpinning the treaty have been put in place, otherwise the treaty is not credible," end of quote. Does the government concede this is an eminently sensible proposal which should be given serious consideration? Taking one example from the treaty, can the Lord Minister reassure us that judges from a mix of nationalities will have been appointed to the new appeals body before any flights take off to Rwanda? And in general, how long does the government envisage it will take for Rwanda to put the protections outlined in the treaty in place? No one on these benches is denying the complexity of the challenges irregular migration presents globally and on our shores. The boats must be stopped, the traffickers must be stopped and held to account, and immigration must of course be controlled. However, this debate is focusing us on the issue of whether or not sending people to Rwanda is safe and humane. The Prime Minister has called on peers to get on board and do what is right. But I fear it cannot be right to assure ourselves that asylum seekers will be protected by a few sheets